Imagine a world where individual rights are not just legal jargon, but are deeply rooted in moral principles. This is the world Ronald Dworkin envisions in his seminal work, Taking Rights Seriously. Published in 1977, the influence of Dworkin's book continues to be profound even today. As compelling as Taking Rights Seriously is, it is not without its challenges. The abstract nature of Dworkin's conceptualization of rights, for instance, has been a point of contention among scholars. Dworkin's view that judges should act as moral interpreters, tasked with deciphering the moral principles underlying rights, has also been questioned. Most notably, Dworkin's work represents a significant departure from legal positivism, the idea that law is solely based on social facts. These issues have sparked rigorous debates, adding layers of complexity and richness to the discourse on rights. At the heart of Taking Rights Seriously is Dworkin's robust defense of individual rights. For Dworkin, rights are not merely a set of rules to be blindly followed. Instead, they are grounded in moral principles and must be interpreted through the lens of justice and fairness. This perspective is a direct challenge to legal positivism, the view that law is simply based on social facts. While Dworkin's defense of individual rights is robust and thought-provoking, it has not been without its critics. One of the main issues lies in the challenge of grounding rights in moral principles, which can be subjective and can vary across cultures and societies. The task of interpreting rights through the lens of justice and fairness can also be fraught with difficulty, subject to personal biases and societal norms. Furthermore, Dworkin's approach potentially conflicts with legal positivism, which holds that law is simply based on social facts, not moral judgments. These issues highlight the complexity and potential pitfalls of Dworkin's approach to individual rights. The book is divided into two main parts. In the first, Dworkin lays out his theory of law and rights. He delves into the nature of legal interpretation, the vital role judges play, and the intricate dance between law and morality. Dworkin's emphasis on interpretation is noteworthy. He introduces the concept of integrity, arguing that legal decisions must be consistent with existing principles and rights. Voiceover. The structure of Taking Rights Seriously has also been a point of contention among critics. Some argue that the division of the book into two parts creates an artificial divide between theory and application, potentially undermining the fluid and interconnected nature of rights. Others have questioned Dworkin's emphasis on interpretation and the role of judges, suggesting that it may overstate their influence and diminish the role of societal norms and democratic processes. The concept of integrity in legal decisions, while innovative, has also been challenged as being somewhat vague and open to subjective interpretation. These issues underscore the complexity of Dworkin's work and the challenges of taking rights seriously. In the second part, Dworkin applies his theoretical framework to real-world legal and moral issues. This is where his approach to rights comes alive. He explores topics such as freedom of speech, equality, and distributive justice, demonstrating how a principled understanding of rights can illuminate these complex issues. Voiceover. While Dworkin's theoretical framework offers a unique perspective, applying it to real-world legal and moral issues has proven challenging. The task of bringing Dworkin's approach to rights to life is complex, especially when we navigate the intricate arenas of freedom of speech, equality, and distributive justice. The nuanced nature of these topics can often muddy the waters, making it difficult to illuminate these complex issues with a principled understanding of rights. These issues highlight the practical challenges of applying Dworkin's theories, reminding us that translating theory into practice is often easier said than done. One of the most compelling aspects of Dworkin's argument is his concept of rights as trumps. He posits that individual rights should be defended, even when they stand against the majority's preferences. This is a powerful affirmation of the inviolability of individual rights in a democratic society. While Dworkin's concept of rights as trumps is compelling, it has not escaped criticism. Some argue that defending individual rights against the majority's preferences poses challenges. Critics question how this stance aligns with democratic principles, which often prioritize collective consensus. Furthermore, the task of affirming the inviolability of individual rights can be difficult in real-world scenarios where rights may intersect or even conflict. These issues underscore the complexity of Dworkin's concept of rights as trumps, reminding us that the balance between individual rights and societal concerns is not always easy to strike. Dworkin also delves into the role of adjudication, highlighting the crucial role judges play in shaping legal principles and ensuring they align with moral considerations. His discussion on equality and justice further illustrates how individual rights intersect with broader societal concerns. While Dworkin's views on the role of adjudication provide a unique perspective, they have also been a point of contention. Critics argue that the role of judges in shaping legal principles may lead to an imbalance of power, with too much resting in the hands of a select few. Moreover, the challenge of ensuring alignment between legal principles and moral considerations is not without its complications. Whose morality are we considering? And how do we navigate when these moralities conflict? Lastly, the intersection of individual rights with broader societal concerns raises questions about the prioritization of rights. Which rights take precedence when they clash with societal needs? These issues highlight the complexity of Dworkin's views on adjudication, as we grapple with the practical implications of his theory. In summary, Taking Rights Seriously is a profound exploration of the role of individual rights in law and society. It critiques legal positivism, emphasizes the importance of interpretation and integrity, champions rights as trumps, explores the role of adjudication, and probes into the issues of equality and justice. It is a book that compels us to view rights not just as legal instruments, but as moral imperatives. This is the world of taking rights seriously. This is Ronald Dworkin's world. And whether you're a seasoned legal professional or a newcomer to the field, it's a world that's well worth exploring. While Taking Rights Seriously has been influential, it has indeed faced criticism on various fronts. Critics argue that Dworkin's conceptualization of rights, his rejection of legal positivism, is too abstract and lacks practical application. Some critics question the role Dworkin assigns to judges as moral interpreters, arguing it gives too much discretionary power to them. Dworkin's clash with legal positivism, particularly his rejection of the separation between law and morality, is another point of contention among scholars. Critics also challenge Dworkin's assertion that rights should always trump other considerations. Lastly, practical challenges arise as critics question how judges can consistently apply moral principles without falling into subjectivity or inconsistency. Despite these criticisms, Taking Rights Seriously has sparked valuable discussions and influenced subsequent debates in legal philosophy. Our exploration of Taking Rights Seriously would not be complete without acknowledging its ongoing relevance. Despite various criticisms, Dworkin's work has had a profound influence on the legal landscape. His critique of legal positivism reshaped the discussion on law's relationship with morality. The notion of judges as moral interpreters, advocated by Dworkin, remains a prominent topic in legal circles. His emphasis on integrity in judicial decisions changed how we perceive law interpretation and application. His conceptualization of rights, especially his view of rights as safeguards against the majority will, has altered how we debate individual rights. These ideas are constantly invoked in debates about civil liberties and constitutional law. His focus on a principled understanding of legal rights has fed into ongoing discussions about legal texts' interpretation. His work has also made us consider the ethical foundations of our legal systems. His stress on law's moral dimensions triggers discussions about the equilibrium between individual rights and societal interests. In conclusion, despite the criticisms, Taking Rights Seriously remains a significant work that has left a lasting impact on legal philosophy. It continues to shape our discussions on the nature of law and individual rights, proving its enduring relevance in the field. Having explored the enduring relevance of Taking Rights Seriously, let's now turn our attention to its applicability in a specific context, namely the Nepalese legal system. Given Nepal's constitutional framework, which emphasizes individual rights, Dworkin's ideas about interpreting and protecting rights could provide valuable insights. His arguments may guide us on how constitutional provisions should be understood and applied. Furthermore, the role of the judiciary in Nepal could see resonance with Dworkin's emphasis on judges as moral interpreters. If the judiciary plays a significant role in interpreting and shaping legal principles, Dworkin's ideas about the moral dimensions of judicial decision-making could be an important consideration. In a country like Nepal that focuses on protecting individual rights, Dworkin's concept of rights as trumps against majority may offer a philosophical underpinning to the efforts to safeguard fundamental rights against potential infringements. Moreover, Dworkin's work could contribute to legal education and discourse in Nepal. As legal scholars and practitioners engage with his ideas, it could lead to a deeper understanding of legal philosophy and the ethical foundations of the legal system. Lastly, the broader social and political context in Nepal could also determine the applicability of Dworkin's theories. If there are ongoing debates about the nature of law, individual rights, and the role of the judiciary, Dworkin's ideas may find resonance. However, it's essential to consider the specific legal, cultural, and political context of Nepal to determine the direct applicability and relevance of Dworkin's theories within the Nepalese legal system. Legal scholars, practitioners, and policymakers in Nepal would need to critically assess how his ideas align with their constitutional principles and legal traditions.